This is Bloomberg Law with June Grasso from Bloomberg Radio.
Donald Trump is a climate denier.
I believe that there's a change in weather, and I think it changes both ways. Don't forget, it used to be called global warming. That wasn't working. Then it was called climate change. Now it's actually called extreme weather, because with extreme weather, you can't miss.
While campaigning for president, Trump called climate change a big hoax. He vowed to get rid of climate policies he dubbed the Green New Scam and the Inflation Reduction Act, Biden's signature climate law supporting clean energy projects. His victory will shake up U.S. energy and environmental policy and have sweeping implications for oil production, clean water, offshore wind development, electric vehicle sales, public monuments, endangered species, and more. Joining me is environmental law expert Pat Parenteau, a professor at the Vermont Law and Graduate School. The previous Trump administration favored fossil fuel development over environmental conservation and climate policies. I mean, broadly speaking, do you expect more of the same?
Yeah, even more of the same. I think it's fossil fuels on steroids, frankly. You know, Trump is promising to go after on day one the tailpipe emission standards that EPA has created, what he calls an insane EV mandate, which it isn't either insane or an EV mandate. It does align with what's happening in the marketplace with EVs, but it's not a mandate for EVs. And, you know, right from the get-go, he has ordered the new EPA nominee, former representative from Long Island, Zeldin, to immediately begin a massive deregulatory effort aimed at climate change rules. He's clearly going to be doing Trump's bidding in going after the power plant rules, the methane rules, and every rule having any negative impacts as they see it on the fossil fuel industry. And the same thing for public lands. It's going to be drill, baby, drill, as Trump has promised in the campaign speeches over and over again. And the question there will be, of course, is there really a demand for a lot more oil and gas?
I mean, let's start with oil and gas. He promised to unleash American energy and free up the vast stores of liquid gold on America's public land for energy development. If you look at Project 2025, they're thinking of drilling in conservation areas even?
Right. The Alaska National Wildlife Refuge, which, of course, has been a controversial subject for decades now. The real question, though, is with oil and gas production in the United States, particularly on public lands, booming under the Biden administration, even more so than it did under the first Trump administration, certainly more than even Obama, which was pro-oil and gas development. And so, you know, there's more land and water under lease right now than can be extracted and exploited. You know, the price of gas is coming down, contrary to what apparently a lot of people who voted for Trump felt. And there's more than enough oil and gas already in the, quote, pipeline that new offers of leases, if they are bid on, they'll be bidded on at rock bottom prices. They'll be almost giveaway leases. There's an awful lot of speculative leasing on public lands, and I would expect to see some of that. But as far as, you know, a clear demand for further oil and gas, in the near term anyway, there just isn't any. There is for the export market to Europe, which of course Trump is targeted, and other parts of the world. And of course, in that sense, we're like any other petro state. I mean, we're producing it for the export market primarily, and that's expected to continue.
Pat, I remember we talked many times during the first Trump administration about public monuments and his, you know, taking back land from public monuments. Do you think he'll target public monuments again?
Yeah, I do. The two in question are Bears Ears in Utah and Grand Staircase Escalante in Colorado. These are both on what we call the Colorado Plateau, some of the most magnificent natural resources in the country, and of course very, very sacred to a number of tribes, particularly Bears Ears. And there is an intertribal, intergovernmental organization that's managing Bears Ears right now. And so the first question is going to be, will he go back to cutting Bears Ears back to about a quarter of the original designation for that particular monument? And, you know, there's not a lot of oil and gas in there, but there are other minerals, including uranium and probably some coal resources and other minerals that might be valuable, copper and so forth. So, I would expect to see Bears Ears and Grand Staircase reduced substantially the way they were before. Of course, all of this is going to go into the courts and be litigated for years. But in terms of Trump's initial public lands moves, I think monuments will certainly be on the agenda.
It seems like there are a lot of top things that he's targeted having to do with the environment. He said he wants to undo Biden's signature historic climate law, the Inflation Reduction Act. Tell us about that act.
Yeah, it is clearly the most significant climate legislation at the national level that we've seen. In fact, I would say probably it's one of the most significant in the world. It talks about investing $360 billion in renewable energy, wind and solar and electric vehicles and buildings and heat pumps and all kinds of things. A lot of benefits for consumers. Its primary mechanism is tax credits and other kinds of incentives. So it's not a regulatory program at all. It's quite the contrary. It's using the marketplace. And it's designed to leverage even substantially more private capital, and it's doing that. In fact, it's doing it in Republican districts all across the country. It will be interesting to see how the new Congress and the House is going to deal with Trump's promise to freeze all further funding under the Inflation Reduction Act and try to, quote, claw back some of the money that's already been obligated. This is going to come down to some legal questions about how much of the money is Biden able to actually put under contract? In other words, lock it up through legal mechanisms before his time runs out in January. I know the administration, from all the accounts, is working feverishly night and day to push as much of that money out the door and get it under legally binding agreements that Trump can't easily repeal or revoke. Of course, with, the Republicans in control of both the House and the Senate, by slim majorities. Even so, I expect to see legislation introduced to try to, quote, claw back some of the authorization that hasn't been completely obligated, and maybe even some that has been obligated. Whether the Republicans have the muscle to push all that through both houses is an open question because of the close margins. But I think it's fair to say that the promise of the Inflation Reduction Act to really move the needle on transitions to cleaner energy and transportation is going to be stalled, if not thwarted altogether. And we certainly won't meet the commitments we've made under the Paris Agreement. And of course, Trump will undoubtedly withdraw us from the Paris Agreement once again.
And that clean green energy money is by design, 80% is going into Republican districts. So there's that. Now, yes. He can't just get rid of that with executive action. What does he have to do?
Unless the funds have not been obligated legally, he does have some control over that. He has claimed that he will simply impound money from the Inflation Reduction Act, but he doesn't have the constitutional authority to do that, at least not according to existing Supreme Court precedent. That's the Chadha case, which Nixon tried to impound funds under the Clean Water Act, and the Supreme Court said you can't do that under separation of powers. Once Congress has appropriated it, you have to spend it or go back to Congress and get them to change the original authorization. So Trump may try to do that, right? I mean, he's fond of saying, stop me if you can in court. So he may, in fact, try to impound funds under the Inflation Reduction Act if he can't get Congress to move quickly to repeal some of the authorization.
Let's turn to water, clean water, drinking water regulations. One of the first rules that it's expected will be on the chopping block is the WOTUS rule, Waters of the United States. What's likely to happen there?
Yeah, so Waters of the United States is the term that denotes the geographic scope of the Clean Water Act. And when you think about the Clean Water Act, it has multiple provisions. It regulates, of course, discharges of pollutants from all kinds of industrial sources, municipal sources, stormwater sources, even some major agricultural sources like factory farms. It creates a system of water quality standards that protect uses of water for drinking and recreation and fish and wildlife and a whole variety of purposes. These are uses that the states individually designate for protection, and then they get the federal protection so that if upstream sources of pollution are impacting downstream state uses of water, then the Clean Water Act allows EPA to step in and make sure that that doesn't happen. And it protects wetlands. It has a lot of planning provisions in it on a watershed basis that looks at entire ecosystems, aquatic ecosystems as a unit, and it gets states to cooperate, like in the Chesapeake Bay, where you have a massive basin that contributes to the water quality problems in Chesapeake Bay. It's the Clean Water Act that brings everybody to the table and gets them to agree on cleanup programs and prevention programs. So when you talk about WOTUS and Waters of the U.S., you're going after the foundation of the entire Clean Water Act in the United States. And the Supreme Court in the Sackett case has already substantially reduced the scope of the Clean Water Act and federal protection. And the Trump administration, at least according to early signs, isn't even satisfied with the amount of reduction of federal regulation of water quality and maybe looking for even further ways of shrinking the scope of the Clean Water Act. We know that red state Republican attorneys general have sued even the scaled back version of the Clean Water Act and are trying to scale it back even further. And so I think we can expect the Trump administration to agree with those red states that are challenging the existing framework of the Clean Water Act. And states, of course, are free to fill the gap and come up with their own programs. But there's been several surveys and studies done by the Environmental Law Institute, which demonstrates that over half of the states have laws on the books that say that states cannot regulate beyond what the federal law requires. So when you take the federal law out of the equation, then there's no protection at all in many of these states. So in terms of water quality, I think we're facing some really serious setbacks, both as a result of the Supreme Court, which of course has 3 Trump appointees on it, and now with the Trump administration in charge of EPA and with Congress in the hands of Republicans who've expressed serious doubts about all this federal regulation. I think a lot of communities across the country have yet to find out, just how vulnerable they're going to be when EPA leaves the scene and nobody takes their place.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Pat Parenteau. Environmental groups are quickly getting in formation to play defense against the incoming Trump administration. This is Bloomberg. The first Trump administration often favored fossil fuel development over environmental conservation and climate policies. Trump has called climate change a big hoax and vowed to get rid of climate policies he's dubbed the Green New Scam. So the second Trump administration might pose even more hazards to the environment. I've been talking to Professor Pat Parenteau of the Vermont Law Graduate School. What about the lead and copper rule regulations where there's a mandate that all lead drinking water pipes be removed by 2027?
Yeah, that's a really expensive item, right? It's going to take a lot of work to tear up older cities' water infrastructure and replace all of those lead pipes. And if you do it correctly, you can't just, replace the main lines. You've got to replace the lines right into people's houses with cleaner, safer lines. That's a huge, almost an interstate highway kind of capital program if you're going to do it across the country. So the price tag of something like that is certainly going to get a lot of attention from the Trump administration and from Congress. And, whether Congress is going to be willing to either mandate that cities, undertake that or provide significant federal funds, as we used to do, to address water quality problems, those are both open questions. But I think going in, you have to assume that once the real price tag is known by the Trump administration, it's probably going to back away from that commitment to provide safe drinking water to people all across the country.
Pat, how many of these are rules so that in order to undo them, they'd have to go through the formal notice and comment rulemaking process to repeal and rewrite the Biden regulations?
Right. So most of these issues we've been talking about are rules. that had to go through the Administrative Procedure Act, notice and comment. And by the way, in Trump 1, EPA and several other agencies, Interior Department, failed to follow the requirements of the Administrative Procedure Act and found that they lost about 80-some% of the cases in which they were challenged. This time around, they may be smarter about that. You'd probably think they would be smarter, but if they're in a hurry, if they're in a rush to show progress on this deregulatory program, they're probably going to be cutting some corners and skipping some steps that are required by law, including notice and comment. And, the environmental community is geared and ready to go. They know the playbook. And I know because I'm talking to them, they're beefing up their staffs. They're hiring more lawyers. They're going to be doing more fundraising. The Sierra Club alone filed over 400 lawsuits against Trump attempts to roll back rules. When you think about Earth Justice, the Natural Resources Defense Council, and many other major environmental groups, they are going to be challenging Trump's and Administrator Zeldin's attempts to repeal and revoke these rules. And it remains to be seen how that's going to all play out in court. We know there are a lot of Trump judges on the federal bench. There are still some vacancies that the Democrats are trying to fill before their time is up. But there's still going to be dozens of vacancies on the federal bench and maybe more over the 4 years of the next Trump administration. So, the prospect for how these attempts to deregulate are going to play out in court, it's an open question right now. Lots of litigation for sure, wins and losses both ways for sure. But, Trump can't do this with the snap of a finger. A lot of it is going to have to go through court before it's resolved.
Power plants, he has vowed to terminate EPA rules that stifle power plant pollution and encourage the closure of units generating electricity from coal. I mean, tell us what his goal is here.
Right. So we know that coal plants are closing, largely in response to the growth of natural gas plants, but also because wind and solar, particularly in places like Texas and Iowa, where it's really a major source of their electricity generation, we know that those other sources are coming online and actually outcompeting coal in terms of the price to consumers. So this idea that the Trump administration is going to try to repeal the rules that are imposing further limits or requirements on coal plants is probably not going to work out in terms of the marketplace. It may have some short-term impacts, depending on how the attempts to roll back the power plant rule, for example, which requires use of carbon capture and sequestration. This is a technology, it's really a system of technologies that the fossil fuel industry has been touting as the answer to climate change. I mean, many coal and utilities and oil and gas companies like Exxon and Shell and so forth, they're all saying that, look, we can continue to extract and burn fossil fuels because we have this wonderful technology that will capture the emissions and sequester them underground in geologic formations, right? But when it came to EPA saying, okay, put your money where your mouth is, we're going to actually require coal plants in particular to either decide to phase out operation of these aging coal plants they were going to give them until 2032 to do that. Or if you want to maintain them beyond that date, you're going to have to install 90% carbon capture systems. And of course, the industry balked at that and screamed that's way too expensive and prohibitive. And therefore, it's not, quote, adequately demonstrated as required by the Clean Air Act. So that's where that battle is going to focus, is on, if you don't require CCS capture technology, then there really is no way to regulate the carbon emissions from coal plants. And by the way, a lot of this focus on these are, quote, climate rules misses the point that they're actually regulating multiple kinds of pollutants, including hazardous pollutants like mercury and other pollutants like sulfur dioxide and nitrogen oxide, which causes acid rain, volatile organic compounds from gas plants that cause all kinds of health problems. EPA's data on the value of these various rules that are now on the chopping block is that their greatest economic value is in protecting people from a lot of other health effects, including premature death, to the tune of about 90,000 people a year that live around coal-fired power plants. So these rules aren't just climate rules, they're public health rules. And if you start saying that we're not going to be regulating these pollutants or transitioning to cleaner sources, and that gets us back to the Inflation Reduction Act. So, the regulations and the investments in the transition to other sources, they go hand in hand. They were part of a package. And if the Trump administration is going to take both the elements out of the package, both the sticks and the carrots, then we have no climate policy at all at the national government. That seems to be where we're headed.
We talked a lot about dangers to endangered species during the first Trump administration. And I saw that the Bureau of Land Management is trying to rush into place protections for the greater sage grouse on federal land before the Trump administration takes office in January. How much are endangered species going to be even more endangered during a second Trump administration?
Yeah, well, the unfortunate thing for the grouse is that its habitat happens to be right in the middle of an oil and gas field. So when it comes to the choice between oil and gas and grouse, guess who's going to lose? Yeah, I think the Endangered Species Act is in serious trouble. That's a law that I, have been involved with for literally 50 years. And I litigated some of the early cases under the act. So both in Congress, and through the administration, I think the act is in serious trouble. Even though it's highly popular with the public, at least when you poll the public on do they want to see strong protections for endangered species, there's a very high percentage, sometimes 80 or even 90% public, support for protecting endangered species and their habitat. But, anytime that interferes with other commodity uses, whether it's oil and gas or mining for copper or other valuable minerals or grazing or any other major economic interest, it's going to lose out. It's one of those laws because it's trying to protect the entire sort of spectrum of species all the way down to plants and insects. And of course, when you think of insects, you think, well, why are we protecting insects? But when you think about pollinators, that's one good reason why we protect insects. They're a keystone species for a lot of food crops. And you could go down the list. There's lots of reasons, economic reasons, why protecting species makes sense and why protecting their habitat is really another way of protecting the communities that live within these areas and helping with climate resilience and dealing with floods and storms and droughts and wildfires and all the rest of that. The healthier your ecosystem, the better able you are to withstand some of the impacts from climate change. So all of this now is going to be debated and argued, but it sure seems clear, and we'll know more when we see whoever is named as the Secretary of Interior, protection for species, which has been not working out very well. I mean, we're still losing an awful lot of habitat every year necessary for protecting these species. It looks like that trend line is also going to be in the negative as well. States, again, can step up if they're willing to and do a lot more of this land conservation work. But, they're also under a lot of political stress from their constituents to open up public lands for even further extraction and development. So right now, it's a pretty hazy picture, I would say, for the future of a lot of these species that are really just clinging to existence and rely on government efforts to turn the trend of extinction around into a more positive direction.
And the Paris Climate Accord, there's no doubt we're out of that now.
Right. In fact, what I read is that the Trump administration is going to try to argue, and I don't know how they're going to do this, through some kind of executive order, I assume. They're going to try to make the case that the Paris Agreement really was a treaty that should have been subjected to Senate ratification. And they're going to try to prevent any future administration from re-entering the Paris Agreement the way the Biden administration did. Now, whether they're going to be successful with that or not, I don't know, it's never been done, but it sounds like not only will they withdraw from Paris, they're going to try to slam the door and lock it.
Well, they may not be looking toward the future as far as the environment is concerned, but they're certainly looking toward the future as far as the Paris Accord is concerned. And Pat, what do you think of the appointment of Lee Zeldin as head of the EPA?
Yeah, it could have been worse. You know, he's not Scott Pruitt. Yeah, that's the best I can say is it could have been worse. His track record has a couple of sort of moderating effects, I would say. First of all, he was instrumental in getting federal support for cleaning up Long Island Sound, which, of course, is affected by nutrient pollution the way a lot of estuaries and coastal waters are. And he's also gone on record as strongly supporting regulation of PFAS, you know, these forever chemicals. And some of the environmental groups that have tried to work with him have said he's at least someone you can talk to about these things. But the point is, he's going to be under the thumb of the White House. His mandate is crystal clear. I want you to start rolling back all of these Biden rules dealing with climate change. And beyond that, you know, any rules that aren't justified by their economics, according to however the Trump administration decides to evaluate that question, and certainly where rules are under attack from major economic interests in the industry. The National Association of Home Builders has been very critical of federal regulation. The Chamber of Commerce is the same. So whenever you have a lot of sort of Republican opposition to EPA rules, I think Zeldin is going to be under tremendous pressure to, if not outright repeal them, certainly not add new protections that have that kind of opposition to them. The thing about Zeldin is he has no experience whatsoever with agencies like EPA. It's an incredibly complicated agency with over 20 statutes that it administers, each one of which is fiendishly complicated with science and technology. So he alone can't really manage all of that. What's going to be key is who does he put into the key positions, the assistant administrators, the general counsel. That level of the agency is the working level of the agency. And of course, Trump has also announced that he's going to go after civil servants with what's called Schedule F, which is a new designation of employees of the federal government that he's going to try to claim are really, you know, political appointees that can be terminated at will without cause. That's going to be yet another big fight. Does he actually have the constitutional authority to do that? But just the idea that part of the game plan for the Trump administration this time around is to go after some of these really senior career professionals that know the real details of the programs that they've been administering for years and decades in some cases, to think that you would eliminate that brain power from the federal government is really quite scary.
I suppose we'll have to wait and see how many of these plans Trump can actually get through. Thanks so much, as always, Pat. That's Professor Pat Parenteau of the Vermont Law and Graduate School. Back in February, the murder of 22-year-old Georgia nursing student Laken Riley became a flashpoint in the national immigration debate because the man accused of killing her was a Venezuelan citizen who entered the U.S. illegally in 2022.
He was an illegal immigrant. He was an illegal migrant, and he shouldn't have been in our country.
Jose Ibarra is charged with 10 counts, including malice murder, felony murder, and kidnapping. Jury selection in his trial was set to begin today, but Ibarra, in an unusual move for a murder defendant, waived his right to a jury trial, meaning his case will be heard and decided by a judge. Joining me is Lauren Johnson Norris, a criminal defense attorney in California. Lauren, this is a murder case that most people in the country know about because it became this flashpoint in the debate over immigration. So a lot of eyes are on the trial.
Well, yeah, it occurred in a time historically in this country where folks are focused on the big influx of immigrants. Some undocumented immigrants, folks who came into the country without status. And so it's become a big political point in this country, not just what we've seen from this recent election, but also in the sort of rhetoric and what's going on in Washington, D.C., and the bills that have been created to address immigration. So I think, unfortunately, for the family who seems to disfavor this type of rhetoric around the loss of their child, I don't blame them. Unfortunately, it has become this contentious point for many and has received a lot of publicity.
What are the charges against Ibarra? It seems like they're pretty broad.
Yeah, and they've listed a number of charges, everything from kidnapping with bodily injury, aggravated battery, aggravated assault with the intent to rape, obstructing and hindering a person making an emergency telephone call, and tampering with evidence. So things that had to do with interfering with her 911 call, to even hiding or concealing the jacket and gloves that Ibarra was wearing. So all of that they've rolled into, ultimately the grand jury came back with these charges.
Is it surprising that prosecutors didn't seek the death penalty in this high-profile case?
I guess I'm a little surprised that they didn't seek it because, it's available. At the same time, it can be harder to obtain a death verdict, and I suspect that they just wanted to make sure that they got the verdict.
The defense tried several things before trial. One, they tried to get the trial moved out of Athens, Georgia. I mean, would that have made a difference? This case was nationally known.
Right, that's a tough one because in the community itself, I'm sure there were heightened emotions and inflamed and enraged feelings around this case that happened, at the university, in a place where people just can really, empathize and feel like it's so close to home. So I do understand why the defense sought to move the case, but point taken, if a case is national news and folks are familiar with it, they may share those same feelings, even in another county. So I'm not sure it'd make that big a difference.
The defense tried to get some evidence suppressed, for example, cell phone evidence.
Yeah, it seems like they sought to suppress evidence based on the affidavits that were submitted to the court for the search warrants. That's one way that they tried to suppress evidence, and the court ultimately said that there weren't any problems with those search warrants and kind of threw that theory out. They also went into his apartment under what we call exigent circumstances to see, if someone is in tremendous danger to society and could be actively hurting people right now, there's an emergency in their home, the police do have the ability to go in for those emergency-type circumstances. And that is where they ultimately arrested him and I believe obtained the cell phone evidence. So those efforts also were unsuccessful. That evidence is coming in at trial.
I'm wondering how strong the DNA evidence is, because apparently it didn't exclude the defendant, but also didn't exclude another known individual associated with the case.
Well, it's really interesting that there's identified a potential other known individual. But at the end of the day, why was this individual, Ibarra's DNA, under the fingernails of the decedent? I mean, that just doesn't otherwise make sense unless there's a theory that there's some other person involved in the homicide. And I think that is strong enough, identifying his DNA under her fingernails, for the prosecution to go forward with a theory that he's the guy that did it. We don't know the details about another person's DNA, what contact she had with other people, where that DNA was located, and why. But the fact that Ibarra was a stranger to her, and ultimately they found all the other evidence that corroborates the charges, I think underscores how important that DNA evidence will be for the prosecutors going forward.
What other evidence do the prosecutors have that you know of?
I understand there is a fingerprint that was found on her cell phone, which would corroborate the charge that he interfered with her ability to call 911. They also located gloves. There's some surveillance video that identified him outside of another person's apartment, where they added the peeping Tom charge that involves him. And what they will argue is that he was in the area looking, to attack someone. And all of that evidence together, I think, is an extraordinarily strong case for prosecuting this homicide.
The defense tried to separate out the peeping Tom charge. Explain how that fits in here.
Sure. So the defense tried to separate it out because any time that there are allegations that are, otherwise inflammatory. I mean, listen, nothing is more inflammatory than an attempted rape and murder. But the idea that he was lurking around the neighborhood, looking into women's windows, suggests that this was planned. He was looking for the opportunity to perpetrate on a woman. And trying to keep that separate ultimately would keep that evidence from being considered in the death of Laken Riley. At the same time, it tells sort of the theory of the case from the prosecution's point of view, how this crime of opportunity ultimately resulted in these tragic consequences.
There seems to be a lot of evidence against Ibarra. Do you see a defense here?
It's a hard sell. I think the defense probably recognizes that the case is inflammatory, the case is horrible, and at the end of the day, a jury would not necessarily look at this in any sympathetic light for this defendant, which is why I think they've gone the way of a bench trial, looking for, I wouldn't say technicalities, but really questions about the law and whether or not each and every element can be proven beyond a reasonable doubt. They may believe a judge is in a better position to make those calls.
There aren't many high-profile murder cases where the defendant chooses a judge over a jury.
Explain the different factors that go into that decision.
Yeah, it's a great question. So we tend to think as defense lawyers that even the possibility that one juror out of the 12 may vote not guilty could potentially hang the jury, leaving the case, in a status where it may get dismissed or retried, giving the opportunity to see the evidence ahead of time, try the case again. We're always hoping if there's one juror who may say not to acquit, that they may persuade other jurors. There's just a lot of hope. The odds are better with a jury. And so traditionally, that's how defense lawyers think. We almost always exercise the right to a jury trial. But the question becomes, in what cases would it be potentially a better strategy to take that in front of a judge? And in my experience, that's where there are real legal questions that are harder for jurors to wrap their heads around in terms of arguments about the law, the evidence. They also ran these motions in front of this judge. And so the judge knows that the prosecution took efforts, even if the judge denied the suppression motion, knows about the suppression motion and may consider the lengths and efforts that the prosecution took to seek to convict here, where a jury would never know about that. And so there just may be reasons ultimately that the defense is strategizing the judges in a better position to hear the technical details of the case that they bring forward than a jury would, because the jury doesn't have that legal experience, presumably.
Prosecutors don't have to put forward motive, but do you think they will put forward motive because the grand jury came back and said it was, I guess, an attempted rape?
Well, it looks like that's the theory of the case and part of the charges here, and there's likely physical evidence that supports that. The fact that also he was looking in another woman's apartment window seems to stir in us kind of an understanding of that might be what was going on here. They don't need to put forth a motive, but I think the average person could see why this occurred. And I think that's important as we talk about what we need to do as a community to focus on the protection of women and why these cases are important to prosecute, also important to get to the truth of and understand why this is happening. I feel badly for the family that their loss of their daughter got thrown into the middle of a national immigration debate. We do know from looking at the studies that ultimately undocumented immigrants are arrested at less than half of the rate of native-born U.S. citizens for things like violent crimes, and a quarter of that rate for property crimes. And so the fact that this morphed into a conversation about immigration instead of a conversation about violence against women, I think is just unfortunate. I think there are greater conversations we could have as a community and as a society about this tragic case and what women deserve. They deserve to be able to run through a park safely at their university without facing risk of harm, potential rape, and death. And I hope we can continue as a community to talk about that more.
Thanks, Lauren. That's criminal defense attorney Lauren Johnson Norris.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. I'm June Grasso, and you're listening to Bloomberg.